Awesome. We're live.
None of us
Hair turned green.
Check with Casey.
Fixed income.
Oh, yeah, that's, I just had to,
wandered into this guy.
Yeah. so I'm just gonna do that.
Mine doesn't always decline it, but I'm changing it.
Hey, everyone. Hey, Walker.
Well, this was just a head. If I get it. Oh, she was.
So I read it in last year.
We didn't have time for the rally. The rally's a 2-hour setup. We're lucky we got this going. You okay?
Yes.
All right, we're ready.
Okay, all right, so we are
We're live and broadcasting
live
from,
and broadcasting. Good morning, everyone. And it's nice to see that we're all positively giddy about the idea of seeing each other. It's good to see everyone and Jeremy. Thank you for putting this all together. Welcome to this. Call the meeting to order and begin with the standard roll call. I'm just going to go right here. Mr. Baker. I'm present. Commissioner Castillo.
Here.
Mr. Bluestone. Here. Mr. Carruthers. Here. Mr. Van Ryn.
Here.
And Commissioner Solomon.
Present.
Thank you. Chair is also present. Approval of the agenda. Is there a motion and a second? Oh, wait.
No. Chair, we need to amend the agenda.
No, that's right. It's just-
So
We're going to do this by deletion.
we are. So the motion I would seek is to remove from the agenda items 4, items 8, item 11, item 12B, and item 12E.
We just skipped the whole thing.
Is there a second? And then what about the stuff on 14?
Also the Rolona part of 14, but that will be gone when we remove item 11.
Right.
That's one.
So I'd like to ask why.
Sure. So Chair and Commissioner Bluestone, a few reasons. First, Rebecca Branch is out sick, and I would prefer her to present the work that she's done to you the next opportunity. So she has an advisory opinion that she's drafted that I'd like her to present, and all of the Rolona cases that she's worked up, I'd like her to have the opportunity to present her work to the commission. Ms. Silva with Common Cause called yesterday and said that she couldn't be here today. And the two items related to administrative complaints in item 12, at this moment, we no longer believe that we need leave to issue subpoenas, given the course of the investigations in those cases. That could change, but right now, the investigations are proceeding without the need for subpoena.
So did you say we're still doing item 7 on potential legislative?
Yes, sir.
Okay, fine. Thank you for the explanation.
Is there a second to the motion? Second. Thank you. It's been moved and seconded to adopt the agenda as amended. Is there any objection? Hearing none, the amended agenda is approved. Next, we move to approve the minutes of the August 5th meeting. Motion and second.
Move to adopt.
Second.
Thank you. It's been moved and seconded. Any discussion? Any objection? Hearing none, the minutes of the other fiscal year. All right, we will next go to item number 5, as for the removed, we just discussed. Item number 5, budget request and strategic plan. Jeremy?
Okay, thank you, Chair. Commissioners, I'm presenting before you, and it was part of your meeting materials, the Commission's annual budget request, our FY24 budget request that was submitted to DFA and LFC in September, along with the strategic plan. That's a requirement for the budget request. In FY24, this budget requests $1,460,200. That's up 18% from the FY23 appropriation of $1,236,000. This near million and a half budget would enable the Commission to effectively bring on 9 FTE. Last year, in the FY23 request, we received approval for 8 FTE, but we didn't receive full funding for 8 FTE. After we had to pay for part of the salary increases out of our own 200s budget appropriation, and I was also able to reclassify Wendy's position from staff manager to AO1, and that comes with a compensation increase for that position. And so given all of that, the appropriation that we received in FY23 was enough for 7 positions. And many of you met Jessica Randall last night, the new attorney that we've just hired. That exhausts the funding for essentially the 200s in FY23. So we have one position on our organizational listing for which we don't have funding. That position is a state investigator position. We're now at the point where we need non-attorney staff to support the attorney staff members in the course of the work. And so the FY24 200s request is sufficient for a non-attorney classified state investigator position. It would also be sufficient for a financial specialist position. At some point when an agency is born and grows, there's so many ASD transactions that just one person cannot handle all the administrative service transactions. As you know, Wendy's been handling all of that, and that's why she merited that position merited the increase from staff manager to AO1. But we need to build depth in that area of the agency because at some point Wendy will move on in her career, and we need someone else that can kind of come up and learn the ASD side of the agency. And we're getting to the point where all of the audit functions, all of the financial transactions, all of the human resource transactions, it's getting near to the point where one person just shouldn't fairly be responsible for all of that. And so we're requesting funding for a 9th FTE for a financial specialist. That funding that we've asked for in the 200s would cover 9 full FTE. We're not requesting any change to the 300s. That's our contracts budget. Right now, our contracts budget is sufficient, and we don't need to ask for additional money there. And then the 400s category is other operating costs, and we're requesting an increase in the 400s that's commensurate with bringing on new staff. When you bring on new staff, you have to pay for additional do-it fees. You have to provide them with the technology they need to work, and there's associated operating costs. So this budget, which is just shy of 1.5 million, is enough to get us through to be able to hire 9 FTE and run the agency with 9 people in 24. And and that's the budget. I'm happy to stand for any questions.
Mr. Chairman,
Go ahead.
Jeremy, what was our original budget when we set this up?
The very original budget that the legislature appropriated for the commission was $500,000.
What is the percentage increase in the budget request for over this year's budget?
18%.
It's an 18% increase, mostly because of personnel.
Yes, sir.
Okay. I'm very satisfied that your book of business has grown rather dramatically over the last year or two, and that we do need additional support, staff support to accommodate that. And my vision of things is it's going to increase even more in the future, particularly as you deal more with the state, the local governments, city and county governments that need some help. I'd be very supportive of the budget request.
Thank you.
Mr. Baker? Have you gotten any feedback from the legislature in terms of, they agree, they disagree?
Well, Chair and Commissioner Baker, we're not at that point yet. Next week, I'll present this budget request to the Legislative Finance Committee, the members. I have had a meeting with the LFC staff and the LFC director about this budget. And from what I understand, they understand it and are supportive.
Thank you.
No, sounds good, thank you.
Yeah, Jeremy, where are utilities being paid out? Are they being paid out of rent, land and buildings?
So Chair and Commissioner Villanueva, yes, our utilities are covered in the rent agreement we have with UNM. This past year, I signed a new lease with the University of New Mexico. So we have the space in the Science and Technology Park. We have a 5-year lease with 2 5-year options. So we have the ability to be in the park for 15 years, and we have very good rates. UNM was very supportive of the commission, and I believe they gave us a great deal on Class A office space in Albuquerque.
It appears that you asked for an increase in the next budget, and I just didn't know exactly what you're accounting for there.
An
Is there
increase.
additional cost when you moved into the new space?
Chair and Commissioner Villanueva, only furniture. We bought extra furniture to build out that space, but that would be mainly it.
Mr. Solomon?
No further questions.
Mr. Chairman, I move approval of the request.
For a second?
Second.
Any discussion? Further discussion? All right, so moved and seconded, try to roll call this probably.
Sure.
Mr. Baker? Yes. Mr. Castillo?
Yes.
Mr. Russo?
Yes,
Mr. Carruthers?
Yes.
Mr. Villanueva?
Yes.
Mr. Solomon?
Yes.
Thank you. Chair votes yes. Budget, the motion carries. All right, next item, Jeremy.
Okay, I would like to invite the Office of the Attorney General to come and be with me at this item. They have kindly come up from Albuquerque to present with me.
oh, I'm sorry, were you going to talk about the strategic plan also?
I'm happy to. That would be part of the budget request, but I'm happy to cover it.
Okay, because I thought we were doing
Okay.
that separately. I'm sorry, just a second. I just wanted to ask a question or two on the strategic plan. There's a reference to undertaking a Financial Disclosure Act compliance project in conjunction with the Office of the Secretary of State. Could you explain that more, please?
Sure, happy to. So Chair and Commissioner Bluestone, that's just a continuation of the same project that we've started with the Secretary of State's office to improve compliance with financial disclosure filings. The State Ethics Commission, with the assistance of some of our contractors, helped to ascertain the universe of folks in New Mexico that are required currently to file financial disclosures. We build a spreadsheet in the winter each year to provide the Secretary of State to help them with ascertaining who has filed and following up with filings. You know, they do a letter campaign for folks that haven't filed, and that's been relatively successful in getting more compliance with filing requirements. So we're going to continue with that project year over year.
Thank you. On the reference to Alona, will there be an opportunity to discuss whether we should consider seeking an amendment to Alona? I know that it allows us now to just renew or revoke or suspend a license or impose a condition on it. And I'm just wondering if it might be more advantageous to have some civil finding authority in addition to those options that we have right now. When would be an appropriate time to talk about that as a possible amendment in our strategic plan going forward?
So Chair and Commissioner Bluestone, every December, the commission produces its annual report to the governor and the legislature per our statute. And that report, as you know, includes suggested legislative amendments to the statutes that the commission has jurisdiction for. So the December meeting, I think, would be the appropriate time to have that conversation, to see if there's an appetite to include that as part of the recommendations to the legislature.
And could I ask you to consider having some work done to prepare an option or two along those lines for us to look at?
Sure, I have no problem with that. I will say that I'm not certain that it's the best addition for Relona, but I really would like to have Becky here and to weigh in on how those investigations and just that administrative docket is going.
That'd be fine.
Okay.
And then I assume it would also be in December, when it might be appropriate for us to talk about this problem, I think, that we've seen with the risk management division having to provide unlimited funding for representation of respondents in our administrative proceedings. And I would like to have some options presented to the commission on how we might address that, and whether there's some cost sharing arrangement that we could propose to a respondent who loses repeated motions and the whole case. Because right now, as we've explained it before, with the unlimited provision of funds for risk management council, they have no incentive to be reasonable in their expenditure of time and money in representing the respondents. And I think we ought to consider whether there's something that we could do to change the law to provide some more fairness and balance in how that work is done. So I would like to ask for some consideration at a December meeting about that. And if you have any ideas or options you'd like to present, I think that would be helpful too.
Chair and Commissioner Bluestone are happy to do that. As the commissioners know, that's part of the State Ethics Commission Act. It's Section 12K. Respondents in State Ethics Commission administrative cases are entitled to risk management counsel, and and those attorneys can run the bill. So that's worth thinking about.
And then finally, and maybe this is premature, but at what point will we be discussing the proposed disclosure act? Will that be part of this discussion now? Or?
No, sir, that's coming up. That will be item 7.
Mr. Chairman, along that line, if you're going to do the kind of work that Commissioner Bluestone is asking for, would you also take a look at the $250 fine, which is the maximum fine for violation of certain, was the former legislator was fined $250, which apparently is the maximum. Is there any reason to consider asking for an increase in that amount? It's not much of a deterrent for the small amount is easily settled just to get out of court.
So Chair and Governor Carruthers, that's precisely what we're about to talk about with the Governmental Conduct Act.
Mr. Sloan? No, thank you. I have no questions for Mr. Teacher. Thank you very much. You can go back on now to item number 6.
Okay, thank you. So I'm here with Ann Kelly. Thank you for coming. So commissioners, on this item, what I'd like to do is to give you my view of the State versus Gutierrez opinion that the Supreme Court recently issued. You'll remember before the pandemic, when the commission met in person, this case was very much on the commission's mind. Jerry came even in those early days to present on the Attorney General's work on this case. And it's taken a few years to work its way through the appellate courts and the Supreme Court. And recently the Supreme Court issued an opinion in State versus Gutierrez. And what they held is that the sections 3A through C of the Governmental Conduct Act are not criminally enforceable, that the legislature did not intend those statutory provisions to create criminal violations. That opinion deals with Section 3A of the Governmental Conduct Act. And the way I've thought about the Governmental Conduct Act, and indeed all of the ethics laws in the state of New Mexico, Section 3A is the foundational principle of government ethics. I think almost everything we do is some instantiation of Section 3A. And it's important enough that I'm just going to remind you what it says. And it's really the second sentence. This is the foundational principle of government ethics. The legislature or public officer or employee shall use the powers and resources of public office only to advance the public interest and not to obtain personal benefits or pursue private interests. That is a broad statement. It is the foundational principle of government ethics. It's a statute that the Attorney General's office has before the Gutierrez case brought criminal charges to enforce. It's a statute that in the commission's first 3 years that we have seen in numerous instances. In our administrative docket, we have pursued Section 3A violations civilly. We've sent demand letters for violations of Section 3A. After Gutierrez, it's no longer clear that Section 3A as such is enforceable. It's certainly not enforceable by the prosecutorial authorities in this state. And there's an open question whether or not the State Ethics Commission could enforce it civilly or in the administrative context. But I don't think that the Gutierrez opinion is in any way spells the kind of the end of this agency, or I don't really even think it limits this agency's powers to pursue ethical violations under the Governmental Conduct Act. And I'm going to tell you why that is. So imagine this piece of paper is all of the possible violations of Section 3A of the Governmental Conduct Act. This piece of paper represents all the universe of all the conduct that would violate Section 3A, all the uses of a government power or government property to pursue a personal benefit. Okay. Section 3A deals with the misuse of power and the misuse of property. The misuse of property is covered separately by Section 3.1c. The Governmental Conduct Act, Section 3.1c, says that it's illegal to use public property for unauthorized purposes. So there's an overlap between Section 3A and 3.1c with respect to property. So that means we're only talking about uses of power. Okay. Misuses of government power can kind of come in two contexts. There could be quid pro quo misuses of government power, and there could be misuses of government power that aren't quid pro quo. And by quid pro quo, I mean an offer to take some official action in exchange for something of value. Section 4A of the Governmental Conduct Act expressly prohibits quid pro quo abuses of office. So then we're really just talking about, those uses of government office that aren't for quid pro quo, that aren't quid pro quo abuses of office. Section 3D of the Governmental Conduct Act prohibits misuses of government office to enhance a financial interest. So that aren't necessarily quid pro quo. So to give you an example, if after I dismiss an administrative complaint for lack of jurisdiction, for example, because the commission doesn't have jurisdiction for the respondent, perhaps they're a local government officer. If I picked up the phone and called an attorney, a friend of mine, and said, hey, there's a potential case here, we don't have jurisdiction, but you might pursue this. And if you do that, you could kick back a little bit of money to me. That would be a misuse of government office. That's not a quid pro quo that would violate Section 3D of the Governmental Conduct Act. So we take that overlap off the table. So really the only universe of abuses of office that Gutierrez takes off the table, the only universe of Section 3A violations that Gutierrez takes off the table from enforcement, civilly or criminally, is those misuses of government power, not property, that aren't a quid pro quo and that aren't for a financial interest. That's 1/8 of this piece of paper conceptually, but actually those cases are very, very rare. Most corruption cases that involve a use of government power are going to be quid pro quo, or they're going to be related to a financial interest. So I don't think that the Gutierrez case really dampens the ability of the State Ethics Commission or the prosecutors, the district attorneys around the state, or the Attorney General to pursue government corruption in the state of New Mexico. It's an important decision. Section 3 is an important part of the Governmental Conduct Act. But I think when we focus on the way that Section 3A overlaps with other provisions of the Governmental Conduct Act, we're still in a very good place to enforce the Governmental Conduct Act with respect to government corruption. Now, all of that being said,
Before you move on, may I ask, just to follow on with your wonderful illustrations, what's an illustration of that 1/8 that rear version?
so to take the 4 consolidated cases in the Gutierrez case, I think the only case that was consolidated among the 4 that fits here is perhaps the prosecution against the former magistrate judge that was using magistrate court property to record employees in the magistrate court. I don't think the record kind of explained why that was happening. Ms. Kelly might know far more than I do about that case, but that seemed like a misuse of office, a use of her power that didn't seem related to a financial interest. It wasn't a quid pro quo. And so it really is the rare case. And, and I would struggle to think of other examples.
What about the DA case where she was charged with intimidating officers, not bringing any action against her because she was a DA? And I don't track, so you know what I'm talking about.
That could be as well. So there are abuses of office that perhaps are off the table, and that's a great segue into the next part, which is the Governmental Conduct Act is sorely in need of amendment across many sections. So the thinking here is I think at least the following changes need to happen to the Governmental Conduct Act. I believe we need to clarify sections 3, 3.1, and 4. I think 3 should be rewritten to make it clear that it's a purpose. It's a purpose section of the statute. And then we could take section 3D of the Governmental Conduct Act, which the Supreme Court didn't touch, and which is a bit more clear that it creates criminal violations, and perhaps move that into another section. Another section in which we redraft 3.1 or 4 to make it clear, the Governmental Conduct Act prohibits abuses of office. It prohibits quid pro quo. It prohibits the use of a government office to violate some other law, which is kind of traditionally how the charge of use of office is used in other state statutes. So some cleanup in sections 3 and 4 are needed in the Governmental Conduct Act. Section 8, which is the concerns revolving door, and we've had some revolving door cases. I think section 8 could be enhanced to make it clear that there's vicarious liability. If you're an employer and you hire someone right out of government office to work for you, and if you knowingly kind of push them into representing, your business or one of your clients in front of their former government office, if you knowingly do that, the business should be liable. It should be clear. I think the business already is liable because that, respondeat superior is part of the common law, and that is kind of baked into how we read statutes that don't expressly say that the common law doesn't apply. So, but we could, if we're working in the Governmental Conduct Act, we can make it crystal clear that in some circumstances, knowing violations by the employer of revolving door laws create liability for the employer. I think that's important. There's a part of Section 9B that deals with legislators representing clients before state agencies. That it's the smallest change you can make in a statute is to change the word "or" to "and." And I suspect that when the bill was drafted, that the word "and" was there, and at some point during the legislative process, it got changed to "or." But essentially, that change enables legislators consistent with the Governmental Conduct Act to represent their constituents before state agencies for pay. And that's not okay. That shouldn't be allowed. So we should fix that, make that change back from "or" to "and," so that legislators are not able to represent their constituents before state agencies for pay. And then last, to Governor Carruthers' point, we need to take another hard look at the penalty provisions of the Governmental Conduct Act. $250 is a transactions cost. That is not enough to deter conduct that's an abuse of office. The CRA, the Campaign Reporting Act, has a penalty structure of $1,000 per violation, up to $20,000 per violation. Hawaii's ethics statute has a $1,000 minimum penalty. So we need to think about the penalties. And something else that we should think about generally across civil penalties across the state. In the federal government, in Congress, DOJ has the ability to increase penalties with inflation. I kind of think that the Attorney General's office should have that power to do rulemaking to, over time, increase the penalty provisions across the New Mexico statutes annotated to kind of keep them along lines of inflation, so that the deterrent power that was intended when the civil penalty was created doesn't get eroded by just the normal inflation that's baked into the economy. So that is kind of my view of Gutierrez and some of the things that I think should happen with the Governmental Conduct Act. And I'm very keen to know what the Attorney General's office thinks.
Mr. Chair, Commissioner members, thank you very much, Jeremy. That was a very good, comprehensive view of Gutierrez. Of course, Gutierrez was a criminal case. It was first considered by the Court of Appeals on these 4 consolidated cases. 3 defendants, which were prosecuted by our office, and 1 defendant that was prosecuted by the 3rd Judicial DA's office. Initially, the Court of Appeals had held that Section 101617 did apply to 1016.3, and therefore that those 3 subsections were criminally enforceable, and that they weren't simply aspirational guidelines, despite the title of 1016.3, which is Ethical Principles of Public Service. The Court of Appeals then considered those 3 subsections to see if they were unconstitutionally vague or overbroad, and found that A did in fact survive, but that B and C did not. B, because it did not sufficiently talk about what conduct was prohibited, and C, because it did not sufficiently talk about what actors were covered by that subsection. And I'm sure, I apologize if I'm boring the members of the commission, and everyone knows this, but just a little background. Of course, both the state and the defendants applied for cert, which was granted by the Supreme Court. Jeremy wrote an amicus brief on behalf of the commission, making a very excellent argument that the court could not find that these subsections were either facially or as applied unconstitutionally vague, and also raising the issue that he just discussed about what does this mean for civil enforcement of A, B, and C under 1016.18. The New Mexico Supreme Court did not address that. I think Jeremy has already covered that. I'm not going to address that part of it. That's not really my bailiwick. But nevertheless, for our purposes, those 3 subsections now are no longer crimes. Those cases will be dismissed. Based on Gutierrez, we have already dismissed some other pending charges in GCA cases and have nullied those counts. So certainly from our perspective, this has taken away somewhat of an important tool for us. I think, again, Jeremy expressed the purpose of A very well. I think of it as kind of the catch-all provision. That the conduct of these 4 defendants, again, was not quid pro quo. It was not necessarily dealing with a government contract or a financial gain, but these sort of other conduct, sort of outlier conduct. And that was one of the arguments we were making to the Supreme Court, was maybe their concerns seem to be that there could be de minimis violations. You know, I use my office phone to make a doctor's appointment. Could I be prosecuted for that? That seemed to be their concern. They talked about the fact that there's no actus reus in A, B, and C. So really, I think their point was people then are left without notice to know what sort of conduct would be prohibited under the GCA. I think Jeremy's point is strengthening A, 1016.3A is very important because, as he says, that's kind of the pole star of public service, of what conduct is prohibited by public officials that's not otherwise delineated in the GCA. And I think that's a very good point. There probably are some quick cleanups based on the Supreme Court's opinion that could be done with 1016.3. One of you probably change the title, which is Ethical Principles of Public Service. That's something that was considered by both the Court of Appeals and the Supreme Court to say, well, these aren't criminal cases. I'm sorry, is there a question? Oh,
You're good.
I apologize. To say that this doesn't, that shows that this is not meant to be criminally enforced. So to take that out, to change the heading to something along the lines of prohibited uses of the powers and resources of public office, required disclosure of interest in public service. We have also sort of discussed internally subsection B because it does seem to be somewhat redundant of subsection A. And again, I'm sort of going to defer to Jeremy's comments on subsection A because I don't think I could express the purpose of that subsection more articulately than he could. But again, the real, I think, crux of Gutierrez was that the court said it was unable to determine what conduct is prohibited. I think the opinion even said it's sort of like just telling public officials to be good. And I think that's an actual term in the opinion. And how can you criminalize something like be good? So there would be a possibility of maybe drafting it to talk about de minimis violations or not going after de minimis violations, the sort of acts that would not be something that are related to your public service, such again as a phone call. It wouldn't be using your public service, using your public office to get any kind of gain. So I don't know if there'd be a way to sort of express or address that concern of the Supreme Court of those de minimis violations. And the other thing I think that would have to be done, although it would not in and of itself be enough, would be make it clear that 1016.17 does apply to 1016.3 and put it directly there in the statute, because of course the structure of 1016.3 is that you have A, B, and C that don't speak about a criminal penalty, and then subsection D, which explicitly does and says it's a fourth-degree felony. So that's something I think both courts struggled with, was the structure of 1016.3, which could be changed to make it clear that indeed the misdemeanor criminal liability of 1016.3 does apply. Or I'm sorry, the misdemeanor criminal liability of 1016.17 does apply to 1016.3. But we support certainly any efforts to strengthen the GCA in the wake of Gutierrez, since again, this did take away an important tool in criminal enforcement for us. The GCA already contains, I believe, the applicable mens rea in 1016.17 of a knowing and willful violation. And of course, it's impossible to foresee any and all or list any and all possible misuse of public authority that could be criminally considered. Gutierrez and the actions in those cases is, I think, a perfect example of that. But the blanket immunity for criminal liability created by Gutierrez, it sets, I think, the checks and balances inherent in our system. The federal government has explicitly left it to the states to define what conduct is prohibited for public officials to take. And certainly we support any effort to help define that conduct. Thank you.
Thank you.
Chair, I have nothing further, just if the commission has any questions.
Chris Baker? Do either of you have a sense of whether the legislature is going to address the issue in the upcoming session? And if so, in what way they will address it?
So Chair and Commissioner Baker, I'm at the moment reaching out to members to see if they'd be interested in supporting a bill.
Have you had any feedback? They're interested, they're not interested?
Yeah, I believe that some of the members are interested, but but we're in early stages. We don't have a draft bill yet, and this is kind of the beginning of this project.
Yeah, I have no questions. Commissioner Baker asked my question. It's good.
Yeah, thank you both for those presentations, very helpful. I gather from what you said, Ann, that you have cases right now that have been investigated or pending that you felt you had to drop the prosecutions because of the Supreme Court decision. And is it your view that unless and until we get an amendment that clarifies a different criminal approach to 1016-3, at least A, and maybe C as well, that you're not going to be able to file any criminal prosecutions unless the conduct overlaps with some other criminal violation? Is that where you are right now?
Mr. Chair, Commissioner Bluestone, yes. With a caveat, one of the cases we had to dismiss the entire case because the only charges were under 1016-3. And to be honest, I have not looked at that case in a great amount of detail yet to see if there would be other charges or other portions of the GCA, but I'm kind of assuming not. And the other one that we dismissed was a multi-count indictment. I think 33, 34 charges on a public official, and it was just one of those counts that we dismissed, and we're not looking to bring another charge on that because it was 1016-3 that was the best fit for that conduct.
And of the 4 consolidated cases that were before the court in Karen's decision, we talked about 2 of them. Do you have any views? Were there other charges that were brought in the other 2 cases that survived?
Mr. Chair, Commissioner Bluestone, yes. And I apologize because I don't have that information and Gutierrez, I don't know because that was the only one we did not prosecute. But I know that there was, with the Padilla case, yes, I believe and I apologize that I don't have that information at my fingertips, but yes. And I think, yes, there was a separate conviction in that case. But Johnston case, no, and Estevez, no.
I'm just sitting here thinking that my old political instincts kick in here a little bit. I think I would write the strongest possible proposals to make the corrections that we think are deemed necessary, and then see how much we have to back off on those when we get to the reality of running it to the legislature. But I do believe one of the things that none of those cases happened in my county, Monroe County. Nothing is more irritating to the public than to have public officials do what a particular individual did. And yet, he was able to hang on to office for a long period of time until finally he was removed. I can't remember the circumstances. I think the public is expecting public officials to behave well, whatever the term used.
Be good.
To be good. We need to define be good in the strongest possible terms. And then realize that when you go to the legislature with these changes, there will be other opinions on what be good is. But I would hope that we would address it in the strongest possible terms and then do what we normally do in a legislative session and accept modifications as we.
I just wanted to say I think the presentations were excellent, and I'm just so happy to know that the 2 of you are collaborating on this.
Thank you. Commissioner Summer?
Yeah, just also thank you for your analysis. It's very enlightening, and I can't help but think ahead about the relative positions of the candidates for the Attorney General, the Office of Attorney General, and their cognizance of the impacts of this particular case and the potential solutions that they may have. So it's just, I don't know. Governor Carruthers, I'm thinking too far ahead, but those are the things that I'm thinking about. Pressing forward, I think, is key in this particular instance. So, thank you.
Thank you. Yes, I'll echo the sentiments that Mr. Stacks is coming. Thank you very much.
You're welcome, Chair. And on this,
Mr. Chairman, Jeremy, would this be a conversation we'd have in December? You would be prepared with the Attorney General's office to make recommendations on these in December?
Yes, sir. So my hope is that by the December meeting, there's a discussion draft for you to dig into.
Thank you, Mr. Chairman.
Thank you.
Thank you, Mr. Chair, for the answer question.
Thank
Appreciate
you.
your time. Thank you. Please, Jeremy.
All right. Number 7 here.
Okay, speaking of discussion drafts, and the recommendations that the commission will make to the legislature in December, there are 2 discussion drafts that were part of your materials and are part of the public materials. One you've seen before, it's the Disclosure Act. This was the version of the Disclosure Act that you have before you in the materials was House Bill 149, introduced by Representatives McQueen, Townsend, and Garrett, and Senator Tallman last session. We always knew that this bill was not going to be germane last session because it doesn't make an appropriation, but we did a lot of work in the commission to kind of get the language together, worked with Representative McQueen to see what he'd be willing to introduce and the other sponsors, and this is the outcome of that effort. There hasn't been any other additions to the Disclosure Act or kind of thought into it for additions since it was introduced last session. I'm told that this bill will be part of the Courts, Corrections, and Justice agenda at their very last meeting after the election in November, but I haven't received hard confirmation of that. So my hope is that that Representative McQueen and I can have an opportunity to present the ideas in this bill to Courts, Corrections, and Justice and see what their feedback is. And the Disclosure Act, just to remind you, it's to improve the deficiencies of the current Financial Disclosure Act. The Disclosure Act requires disclosure of the sources of income north of $600, which you would have to report to the federal government in your IRS tax filing. It requires the disclosure of any asset worth more than $50,000, not the amount, but just what the asset is. It requires the disclosure of liabilities, and it requires the disclosure of gifts. All of those items are not currently covered in the Financial Disclosure Act, and so the Disclosure Act is really intended to enable the public to have a real opportunity to check whether or not there's conflicts of interest or potential conflicts of interests by the filers of the Disclosure Act when they take government action, when they employ the uses of their government office. And so commissioners, it's before you today to see if you have any additional thoughts that need to be considered in the run-up to the December meeting and to the December annual report, because it's very much, I believe, our intention to see this introduced in the next session when it will be germane.
Have you gotten any feedback from folks regarding your suggested changes?
So, Chair, Commissioner Baker, I have from the sponsors, and it varies. Some of the sponsors are very enthusiastic about this. Other the members, as you might imagine, have some trepidation about what this might mean for them and their spouse. And I believe that we can expect every member of the legislature to approach this bill with the perspective of what does this mean for me and my family. And so that's an important perspective to take into account, and also why it really should be aired before CCJ before it's introduced.
So with respect to conversations where folks have said they have trepidations, have they articulated what those trepidations are?
Sure.
Or is it just this sort of vague?
It would be concretely. It would be with respect to business clients of my spouse, and the business clients of my spouse might not want, that business relationship is right there for the whole public to see. There's also some I think concerns about what this might mean for the attorney members in terms of disclosing their sources of income. And part of the Disclosure Act is written to address that issue. If you're in a firm with if you're a member who's in a firm with other folks, how far those disclosures have to go. And in the act, it goes to if you worked on the matter that's being represented in your firm and the income's coming in, then you have to disclose it as part of the required client disclosures. So those are the two areas.
So hypothetically, if you are a sole practitioner attorney, your client list is going to change over time. Yeah. Would the thinking be that every time you have a new client, you need to amend the disclosure?
That I'm not sure about. You certainly would have to include that new client in next year's filing under this bill. But I don't know that it answers that question and requires that additional disclosure with every new client you bring in.
Thank you.
First of all, I think it's a really good idea that we're going forward with this. And I like the idea of talking to the CCC, the courts, that particular committee to kind of get an idea of what's happening. So I'm happy with your work and I'm looking forward to seeing what reactions we get when this does get presented.
Thank you.
Yeah, I do think it's a good bill. I think we need to have more information in the public domain to allay fears of conflicts of interest, provide for reasonable disclosures. I like the idea of providing for disclosures of the nonprofit ones, as well as the for-profit ones that office holders are on, because I think that can be an important disclosure that the public should be advised about as well. One issue that we've talked about before as a commission and that we've taken a vote on in favor is requiring disclosure of the legislators whose spouses, children, or parents are registered lobbyists. And I don't see that in this bill. And I think just as the commission has urged that disclosure before, I think we should ask and go on record having that be included in the bill or presented as an amendment on behalf of the commission. I think that there is always that saying, the devil's in the details. Personally, I think a minimum requirement is that if you are a legislator and you are married to a registered lobbyist, or are the son or daughter or father or mother of a registered lobbyist, that you ought to have to disclose that. And then we can rely on at least on the press to do its job in disclosing what the bills are that are being worked on. But I'm not sure even now, under the lobbyist regulation now, if the lobbyists have to disclose the particular bills that they're working on. I think they just have to disclose the nature of the issues that they're lobbying on. But that should be checked. I mean, I would rather see as much of the burden of disclosure be placed on the lobbyist rather than the legislature in terms of each time a bill is up before a committee to do that. But when we get down to a bill on the floor, I still think that it would behoove the public to know that a legislator, it doesn't mean that they can't vote, but that they should be asked to reasonably disclose that my partner is a lobbyist in favor of this bill or against this bill. How those details get worked out, I think we can leave to each body to determine. But I think at a minimum in this disclosure map, I would urge that we go on record as asking for there to be some affirmative disclosure by the legislators when their spouses, partners, parents, children are registered lobbyists in that state.
Mr. Chairman, I was looking, where's the proper place to address our discussion on attribution? That we discussed in the last meeting or two. had to do with people using the corporations. Are we going to address that? And if so, where would you address it? Would it be in a bill such as this?
It would be in the Campaign Reporting Act, Governor,
Yeah, the campaign reporting that?
which is the next bill up.
Okay. Thank you.
Jerry, I looked through this, I looked through this drought that worked on weekends. What's the consequence of not filing? I think we discussed that.
Well, there are civil penalty provisions. There's also the ability for this commission to adjudicate an administrative complaint. If we receive a complaint that someone didn't file, I believe the commission has the ability to make them file, and we can pursue that through the courts if we had to. I don't off the top of my head know the maximum penalty provision that's in the Disclosure Act. One consequence of not filing could include a criminal prosecution. And part of what the Financial Disclosure Act does, or the Disclosure Act does rather, and this was at the request of the Attorney General's office when we were prepping this last time, was to include the statute of limitations, to expand the statute of limitations to 5 years. Oftentimes, from what I understood, the Attorney General's office won't realize that there's been a violation until the statute is nearly run. And so, yeah, there's a mix of potential criminal and administrative and civil liabilities.
Thank you, Mr. Solid. I think some questions that I had have all been answered, especially about whether it's regarding contribution aspects of this. So just leave that. Thank you.
Thank you.
Stuart Chestnut used the word journalists or reporters, I don't remember which. And as the years go by, fewer of those folks actually exist. And to the extent they do exist, there's a lot of stuff to do. And this is maybe further out in the weeds than somebody covering the Capitol might necessarily ever want to see. So anything that points them and makes that a little bit easier to make, I think is more important now than it was 30 years ago. For that very reason, we don't have 20 people covered. We have 2 really covered.
Mhm.
The counter to that, and I can hear the arguments, really, is at what point does the government reach a little too far into the personal business of my spouse? And that's the obvious one. Going back to what Governor Carruthers said earlier today, I think the idea is put everything in there and figure out what needs to be jettisoned in order to make the thing work. So, as written, it seems like that's obviously what's the intent. My concern is also that the fewer things like this, the less likely it is that the ink-stained wretches, to the extent that they even exist anymore, will find stuff that they might have been in a pre-internet conversation. So I can thank you. You want to move on to the campaign reporting?
Sure. Thank you, Chair. Commission, the next bill that is before you is a discussion draft. This is something that I've recently received from council service, from the drafters, as a consequence of work that we started over the summer with Senator Worth, with folks from Common Cause, with the Secretary of State's office, for amendments to the Campaign Reporting Act. This bill really addresses 2 issues in the Campaign Reporting Act. The first issue that it addresses has to do with loans that members of the legislature personally make their own campaigns, and the debt that campaign committees owe those members. Right now, there are 3 members of the legislature whose campaigns owe them more than 6 figures. We really don't have very much in the way of a regulatory regime around personal loans that candidates make to their campaigns. It's absolutely a First Amendment right that they can do it. But we don't really have disclosure about that. So part of what this bill does is requires disclosure of the loan terms that's of a loan that a candidate makes their own campaign. This bill also will prohibit that candidate from charging a rate of interest on a loan that the candidate makes their campaign. And the idea there is if a candidate were able to charge interest on a loan that they make to their campaign, then they can essentially convert campaign contributions, because campaign contributions can be used to pay off debts. They could essentially convert campaign contributions into a source of income. This has happened around the country. A congressional candidate, I think, made over $250,000 in interest payments off of campaign contributions based on a loan that she had made her campaign. So we don't have any law about that right now. Right now, it is legal in the state of New Mexico for a candidate to loan their campaign money at interest and to use campaign contributions to pay down the interest payments. I don't have any indication that that's happening, but we also don't have any idea that it isn't, because there's no disclosure around this. And so there's no disclosure around this. So one thing that this bill does is addresses personal loans that candidates make to their campaigns. The other part that this bill addresses is it really is focused on disclosure of the funders of independent expenditures, and it tries to amend the Campaign Reporting Act to force more disclosure over really the out-of-state money that's coming in to fund independent expenditures in New Mexico. Campaign Reporting Act has a couple of gaps with respect to that. The deepest amendments in this bill are in section 27.3, which deals with disclosure of folks that fund independent expenditures. And it works to achieve more disclosure in that regard. Governor Crothers, this bill does not address the issue of attribution. That's not a topic that was discussed with the members. I'm not sure that the sponsors of the bill would be inclined to see that clarified. 5 members of this commission believes that the Campaign Reporting Act already requires contribution limits to have force and effect with respect to contributions being routed through LLCs based on the vote on the last advisory opinion. So attribution is not something that this bill addresses.
Mr. Becker? No question?
No, thank you. It's, I think it's good that we're looking at these issues.
In terms of the loan issue, I gather that before this goes into effect, right now or in the past, somebody could have just stated that they had made a loan to their campaign, and there'd be no evidence of the loan provided, and then campaign money is used to repay the alleged loan. Is that
So
the problem that can exist right now?
So Chair and Commissioner Bluestone, that's right. That's the most egregious problem that this bill attempts to avoid. Is right now, candidates do not have to provide proof that they've made a loan. They have to report that they've made a loan to the Secretary of State's office. But if a member was sufficiently venal, they could just write down that they've loaned their campaign $200,000 and then use campaign contributions to pay down the loan of $200,000. So this bill requires proof that a loan was in fact made, in addition to the loan terms, in addition to prohibiting a rate of interest. Thank you for that.
And in terms of the attribution issue that Governor Crothers mentioned, has there been a proposal to be expressed about this, that any loan by a spouse or a LLC, or any contribution by a spouse or an LLC, shall be deemed to be attributed to the person who is the spouse or the owner of the LLC. Has there been discussion of making that explicit?
So Chair, Commissioner Bluestone, no, that wasn't one of the topics addressed and that led to this bill.
Thank you.
Mr. Chairman, Jeremy, do you think there ought to be a clarification on attribution in this one? Do you personally think that?
So Chair, Governor Crothers, I do, but I'm also inclined to believe that some of the members that might sponsor this bill and carry it might believe that the limit's might after the Citizens United opinion and Republican Party of New Mexico, which enables independent expenditures at any level, I think some of the members might think that contribution limits inhibit their ability to fight some of that campaign spending. And so I'm not certain that they would be inclined to see the attribution rule clarified to make the limits bite harder, because I think they need the money. So that's why it hasn't been part of this discussion, because I think that's harder. I think that would be a lot harder to get through than these items that deal with dark money and candidate loans.
Well, sometimes you have to gradually sneak up on these things over time, but it strikes me that, and I know some of the people in past documentation I've seen have used their corporations to far exceed the limitation of $10,500 for a statewide office, and some of them are up in $40,000 and $50,000 and $60,000 by using their corporations. To me, that they're skirting the intent of the law, which is to limit the influence of money in a campaign to a reasonable number, $10,500. And this is a good Republican. I shouldn't say this, but probably Republicans do it better than Democrats do it. Maybe because
From what we both do it.
she's from down there. There's
No
quite
objection
a
to this, Democrat.
yeah, there's quite a few people down there that can afford to do it through their corporations, and maybe not so much for Democrats, but it's a little offensive to me, and I think it's skirting the law to do it. And so, what I'd like to see in December is just language that we could ponder, that might help clarify this, and then we can pray over it for a little while. And, it is my thought that at the moment, the New Mexico Ethics Commission is viewed by those who pay attention as a real honest worker. And we shouldn't lose sight of the fact that at the moment, we're considered an honest worker of trying to clarify rules, regulations, laws, and everything else on behalf of the public. And we should lose sight that that is one of our responsibilities, is to continue to be an honest worker.
Chair Governor, I'm happy to draft the language.
Thank you.
Commissioner Deloitte?
First of all, I just want to clarify that I do not have those corporations, which the Commissioner mentioned.
Put your paddle around the whole.
I know them. Okay.
I will too.
I think this is more for comment, since you have not seen anyone who has given a personal loan to their, I think you said that you have no experience of anyone seeing anyone given a personal loan to their company, have you?
No, Chair and Commissioner Villanueva, many of the members loan their campaigns from their personal funds. There are many personal loans from members to their campaigns. What we haven't seen, and what I don't have any concrete evidence of, is charging a rate of interest. But several of the members do make those loans.
Yeah, other than making loans, I just think as a point of interest, I think if there's some business issues related to loaning or campaign, and that somebody should be issuing 1099s. And perhaps there should be some business contracts stating that they are giving a personal loan and what rate.
Mhm.
So just if you happen to want to address that somehow.
Thank you. Commissioner Solomon?
I don't have any additional comments, Mr. Chair, thank you.
Thank you. Aaron, what I hear you say, there's no appetite among the sponsors for the provision of steward development. But to the governor's point, just because there's no appetite doesn't mean we shouldn't pitch it out there and they can take a bite at it, leave it alone as people wishes. But I think he's right. I like, you're right, unless all of our perceptions are way off. I share that with them publicly, basically, we're doing what they could do. We know it's not going to go, but that doesn't mean, like the noise and tenders from them.
So Commissioner White, what I hear you saying is, well, this is going to be part of the annual report. This is part of the push.
Mr. Chairman, if I might,
Yes, sir.
I think some of these people who are doing that will probably welcome the opportunity to reduce their expenditures.
Yeah.
They've been doing it for a long period of time. It's an expectation that they do it. And surely they have the money to do it, but sometimes I think they do it because it's a practice that they've become accustomed to and would probably not be overwrought with anger if they had to reduce their total expenditures to $10,500.
30 years. Thank you. All right.
Not just like,
But you first, is there a motion to go into executive session? Any objection? Bring them to go to executive session, but we will start that with a step back.
Thanks for coming, Paul.
That was my pleasure.
We have another room, but after Paul leaves, we could stay in this room and just turn the stream off.
Yeah.
Okay.
Bar the door.
I thought the gallery was going to be full of reporters. I dressed up.
Just in case, right?
That's not nice.
We look pretty good, Jeff.
Well, thank you.
the telephone reception in here.
It's pretty good, huh?
Yeah. I don't know if you're talking to people up there, if you talk to them, they just feed away.